Mr. Ostergren, you can proceed.
Thank you. May it please the court. My name is Alan Ostergren, and it's my great privilege to be the Muscatine County Attorney. First of all, let me thank the court for granting oral argument, a privilege not normally granted to pro se litigants. I'd like to start by addressing the question that I know I'll get asked anyway if I don't address it, and that is, what's the harm? What's the harm with the district court's administrative order? And let me emphasize that I believe that it's entered with the best of intentions. The order's intent is to empower victims of domestic violence. But what we in the law enforcement community and this court knows through the bitter experience of case after case after case of domestic violence in our court system, and not to mention all the cases of domestic violence never reported. What we know is that the way you hold an offender accountable for domestic violence is an adjudication of guilt in court for his violent behavior. The order's intent is to empower the domestic violence victim by giving her the opportunity to go to court herself directly. But unfortunately, you cannot, through procedure, empower a domestic violence victim. All you can do by that procedure is empower her offender.
I understand your argument, and the policy behind it, but tell me where in the code this administrative order violates some code provision.
Well, I would say there's nothing in the code that authorizes it. And in fact, what we have is essentially the rules of criminal procedure being amended in one county. The code, Chapter 664A, does give the victim a direct access to court in one location, in subsection 8. At sentencing, when we go from a temporary no-contact order at the adjudication and disposition of the case, the code specifically says the victim gets input, and at the extension of that order, the victim has input. The court has a new decision to make.
But you get this restraining order. This is a no-contact order, not a protective order. But you get this no-contact order, and you do it without the advice to the victim sometimes, because it sounds like it's almost automatic in these cases.
It's automatic.
But what about the victim's constitutional right to assemble with who they want to? I mean, what you're doing is you're taking away that victim's right to decide who they will assemble with and who they won't assemble with. I mean, how do you answer that part of the equation? Well, you've taken away the victim's choice.
That is inherent in a criminal prosecution. And when we think of the constitutional right to assemble, which admittedly is not briefed, but I'll take a stab at that, Your Honor, we talk about political activity. I think when we use that in the First Amendment or read that in the First Amendment, we understand it to mean for political purposes. And the interpersonal relationship between two people that is severed by a temporary no-contact order is not the kind of thing that the Constitution talks about with a right to assembly, and is inherent in the disposition of any kind of criminal case. Suppose the offender goes to prison. Well, there's not going to be assembly, or there's not going to be lots of things between the offender.
They could go visit him in prison. They could correspond with him. They could do anything they want.
Not if there's a no-contact order, they're not. And not if it doesn't meet the correctional objectives of that offender's case, they're not. And I think the lesson there is that what the criminal justice system does in specific cases does not mesh up well with how we understand the right to assembly.
Isn't your real beef in this case is that you don't want the victim talking to the offender and recanting? I mean, isn't that what you're trying to avoid? I mean, we've seen that problem in 5 to 10 cases in the last few years with confrontation clause issues and hearsay issues. I mean, isn't that really what your stake in the thing is? Because you don't want that victim to recant after seeing the offender again?
I don't want the victim to be pressured by the offender. I don't want the victim to be re-victimized. Recantation is part of that, but it's really not the most serious part of it, quite frankly. It is the continued pattern of power and control that the offender has over her. You see that in recantation. But quite frankly, what most prosecutors would say is that if she recants, we're going to go forward on an evidence-based prosecution. We'll do the best we can. That's why you get those confrontation clause cases. That's why we fight about excited utterances and statements for medical opinions and things like that, because we're going to go forward and fight that case out in court as best we can, even if she doesn't want to. We're not going to stop just because we have some excuse not to.
Counsel, I hear your argument, at least in your papers, to be something like this. We shouldn't let the protected person seek modification of these orders. It's important to have the state in control of that, because the state can do a better job of making an objective determination of whether the protective order should or shouldn't be modified. But why? My question is, why isn't the court going to serve that purpose? In most of these cases, if the state doesn't consent, you're going to have a hearing. And why shouldn't we view the court as a sufficient protective intervener here to stop modification when it shouldn't be granted? And in fact, in the Orr case, the court said, no, we're not going to modify this order, right? So expand on that.
Well, first of all, it's what's the role of the court? The court should be a neutral in letting the parties litigate their case from start to finish. I don't doubt that Judge Rydell or any other judge in the trial courts will do the best job that he or she can when a hearing is in front of that judicial officer. I don't doubt that. But the question is, what can the court really do in a 5 or 10 minute hearing to sort out the fundamental issues versus what I can do with that victim in my office, and the fact that the victim has to come to my office in the first place, and the fact that I'm supposed to, as a prosecutor, be weighing all those considerations. What's in the best interest, not only the victim, but other people who are protected by the order, typically minor children is who we're going to be concerned about. What are the factors in this case? There's no two domestic cases that are the same. And so the way our system works is people like me are supposed to use our experience and judgment to sort those things out, and then we go to court and a judge decides ultimately.
Mr. Ostergren, I mean, you make some good policy points, but let's focus on the language of the statute. Would you agree with me that 664A3 allows the court sua sponte to modify a no-contact order?
I think the answer is yes, because the law on this is pretty general, that these kinds of orders are always subject to revision.
All right, and that being the case, can't Judge Rydell, as sort of regularizing that exercise of sua sponte authority, say these are the circumstances under which we will invite the victim to come in and apply to the court for the exercise of that authority?
You know, Your Honor, I assumed I was going to get a question like that. And sua sponte is one of those terms that we use and we never really talk about what it really means. On the court's own motion. What's that mean? On the court's own motion. I don't doubt the principle in general that courts can realize some mistake has been made, I need to fix something that I did before. But on the court's own motion takes on no meaning in an adversarial system if what it means is the court invites the parties to litigate the case differently than they're litigating it. And it's not on the court's own motion, it's the court inviting the victim to make a motion. And to call it sua sponte is calling it what it isn't. It's calling it sua sponte when the victim is initiating that process. And that's the problem. The victim is not a party to this lawsuit.
A question, I'm sorry. But this administrative order was only entered in Muscatine County.
Correct.
In the 7th District, is it in any other county that you're aware of?
I'm not aware of that.
You know why the court felt compelled to enter this order in Muscatine County? Did something happen?
I know why. It's not in the record. I mean, it's out of concerns by the victim advocates that they don't like the fact they have to go to my office first. That's not in the record, but that's why. And I think...
Well, and I have, I guess, a little bit of a concern about this. You know, anytime you have a criminal prosecution, and I understand you're a very important role in this whole process, but oftentimes, you know, charges get filed, that's your decision. as the county attorney, whether to file these charges in any event. Somebody in a domestic situation is going to get arrested, but then, and at that point, you're probably going to have a no contact order entered. The victim in this case really has no input in that. They have really no input onto whether or not you're going to file the charges, or I think it's routine, they're going to get a no contact order whether the victim really likes it or not on that particular set of circumstances. But upon further reflection, doesn't the victim have an individual right to come in and say, you know, I want some control over whether I feel I need the protection or not, free of, you know, your other policy reasons for wanting to be in control of the situation?
In a general sense, yes, Your Honor. But that comes from my relationship with the community that elects me to do this job. And that principle is true, but if it's taken to the point where it affirms this order, what it means is then the court is supervising how I do my job as a prosecutor. There's
Well,
no.
I don't see it quite that way, but I understand you could certainly see it that way. I don't think it's any attempt by the district court to try to usurp any decisions that you're making, either as a prosecutor or to lift or not lift the no contact order. I mean, do you typically, if you have a situation like this, do you agree to lift the no contact order if there really isn't any basis for doing so?
I would say my typical practice is, first of all, I try to engage that victim in a conversation about why she really wants the order. If the offender's out of custody, the first thing I ask her is, who drove you to my office? And when you get the blank stare, there's a good chance he's in my parking lot. We go in a back and forth. Now, I'm going to take that application over to court. Sometimes it comes over with my form on the top that says I'm opposed to this. And sometimes it gets sent for hearing, sometimes the request gets denied. But it has to come through me because it's such an inherent part of prosecuting a criminal case. Do we really think...
But again, you're saying it has to come through you, and I guess I'm going to challenge you on that as to why it has to go through you solely from the standpoint of managing your criminal prosecution, and why that takes priority over the individual's rights or any individual's rights that may come in and say, I don't want or need this protection anymore, but the state says they're not going to agree to it and we have to have a hearing.
The whole premise behind what we're doing with domestic violence prosecution is, frankly, we're treating domestic violence like we treat all other kinds of crimes. We, you know, in popular culture and the vernacular, we think about, well, I'm going to drop the charges. Okay, victims can't drop charges, which is, I think, frankly, a very surprising point that was made in the other side's brief here. The suggestion that there's good policy reasons why victims should be able to dismiss a domestic violence prosecution. And all I can say is that is absolutely wrong. And that, you know, the idea that, oh, we're going to help the victim, all we're going to do is put a target on her back. The offender can't manipulate me. I don't want to be in a relationship with him. I don't have kids with him. I don't want to go to counseling. I don't want to make it better. Okay? He can't manipulate me. The problem is he can manipulate her. The domestic violence, the act that has caused him to be charged with a crime, is a overt manifestation of a whole pathology of control and violence in that relationship, which is also manifested by you go down to court and you get that no contact order dropped.
Isn't it the court to decide whether she's being manipulated or not? It could be a he too. You keep saying she, but whether the victim's being manipulated, isn't that the duty of the court, not you?
Certainly, well, under this regime, the court is taking that role on. And what I'm suggesting is that's law enforcement's job to do while that case is pending.
Is your role adequately protected by the fact you get notice and can come and, I assume, participate in the hearing and weigh in?
No, and the reason being is that I don't get to be that buffer. I don't get to be the buffer between making her come to the county attorney's office versus making her come to the court. And obviously men are victims of domestic violence too.
But you say there's a victim advocate, I mean, who works with the victim on these things too. I mean, so you can overrule the court and you could overrule the victim's advocate because it may not be good for your prosecution. I mean, that's what I think you're telling me.
I'm not telling you that. I don't, and I'm about to have a red light, if I may answer your question, Your Honor.
Go ahead.
I'm not trying to overrule the court. I'm just trying to do my prosecution function. The court is going to enter orders. The court is going to sentence the defendant, and that is Judge Rydell's job, or just like any other judge's job. And I'm not trying to overrule that. But what I'm trying to do is do that verb, to prosecute. And that comes with a whole host of things, getting that case from a 911 call to a sentencing order. And this process fundamentally undermines my ability to do that. I'm not trying to
You
overrule.
see your job as a prosecutor to convict everybody you charge.
I see my job is to do justice. Now, and again, if I could follow up, because I still have a red
Go
light.
ahead, why don't you follow up and then summarize?
Thank you.
Sorry.
My job is to do justice. Now, if I've done my job correctly in evaluating a case and making a charging decision, then the natural consequence of that would be a conviction would be justice, an adjudication of guilt. But my job is to do justice to the victim, to the defendant. I have just as much legal obligation to the defendant as I do the victim, and to the community at large, who is truly the victim in our system of justice. It's the community. You know, the allegory of the law being portrayed as the figure of justice carrying a sword, it is that I referred to in the brief. It is the community's interest in seeing that justice is done, and I'm the person who's supposed to do that, Your Honor. I would ask the court to sustain the writ of certiorari and find that the district court was in excess of its authority in entering the administrative order. Thank you.
Thank you, Mr. Renner. Mr. Walker, I'm sorry.
I'm happy to be referred to in any way the court chooses.
You may regret that.
It's fair. Good afternoon, and may it please the court. Thank you, Your Honor. Counsel. My name is Renner Walker, and I'm representing the state in this matter. This case is about fair access to the courts. It is not about what role a protected party can play in the prosecution of a criminal case. It's not about how best to ensure the protected party's safety. And frankly, it's not even about whether the protected party has a right to seek modification of a no-contact order. In fact, what this case is about is whether the district court has the authority, under either statute or its inherent authority, to issue an administrative order creating a basic procedure protected parties under a no-contact order can follow to seek modification of that order when two cases of this court indicate those parties are subject to that order and limited by it. In this case, the text of Chapter 664A, the court's inherent authority, and constitutional values surrounding due process reveal that the district court had such authority.
Counsel, Counsel, let's just assume we're past the problem of whether there's authority to enter the order. I'd like you to consider and talk a little bit about the possible prudential concerns that the court might have from an administrative perspective in whether we ought to have 99 or I guess maybe 100, we have 100 courthouses, whether we should be approving the implementation of local rules of this type in all these county courthouses, and the problem that can create for uniformity and all the rest. So tell us about your thoughts on that.
Well, Your Honor, uniformity is absolutely an admirable goal, and guidance typically through written decisions of this court can be crucial in supporting a regime of uniformity. Administrative orders traditionally are certainly within the county structure itself would be a uniform method of dealing with the letters from victims or protected parties that come in. And I suppose in the pursuit of uniformity, my final point on that subject would be that that's exactly how common law has worked in other fields of the law as well. And so a district court taking a shot at one approach to dealing with a problem that I think for the purposes of this question, we assume that it has this power, a district court taking one shot at dealing with that problem can be treated as persuasive by other courts around the state and can, of course, be considered for its value by this court.
How do you
Our
answer
court,
the,
should our court micromanage local district courts, or should we allow some experimentation, have a laboratory, see how this works?
The word laboratory there is a key one, Your Honor, and it sort of harkens to Justice Brandeis's famous line about laboratories of democracy. And that is certainly a salutary function that courts in the judicial system can serve, and particularly to draw an analog to federal courts. Local rules are a common feature in the federal court system that permit narrowing and specifying of the way rules apply at the local level, so long as they don't contradict larger uniform rules.
here's one of my problems with your position is that the protective order is entered based upon the work of the county attorney, and almost in that situation, the county attorney is the victim's attorney for that purpose. And they have this attorney-client relationship, sort of, not really. And then the district court's saying, well, forget that attorney-client relationship. The victim could bypass it without seeking the advice of the person who obtained the order for you and come into court. Now, maybe this is unique or not, but tell me why that's, you know, we wouldn't allow that in any other situation where a private attorney went in and got a no-contact order and was still attorney of record, and then the victim tried to go in. Why would we allow it in this case?
There are two things that I'd like to say about that, Your Honor. The first is that if it's a private attorney, and if we were to imagine, say, for example, a civil context, typically the client can fire the private attorney, and though there are limits on the client's ability to do so, the power is not necessarily narrow. The second point, I think, is that ultimately down the line, if the protected party here, and protected party status is a broad concept, it's not just the victim, it's the victim's immediate family and victim. If a protected party, who in this case might be, again, the victim's brother, parent, or roommate, and not the county attorney's quasi-client, is going to be subject to the no-contact order, it would be anomalous from a due process standpoint that the first opportunity that protected party had to weigh in on the propriety of the no-contact order's terms would be at that protected party's own show cause hearing. So some measure of procedure up front is helpful to prevent.
Well, maybe it's helpful, but let me ask this question, if I understand it correctly. We're dealing, at least in part, with inherent court authority. We have cases dealing with inherent authority, as you know. But ordinarily, inherent authority arises in the context of something that's absolutely essential to allow the court to do its job. If the legislature didn't appropriate any funds, maybe we would have inherent authority to keep the courts open. We've said we've had inherent authority to require district courts to state on the record reasons so that we can have meaningful appellate review, because otherwise we don't. But inherent authority is sparingly exercised, and it may be that this is a nice order. It may be that it has some merit to it, but give me your best case on why the district court had inherent authority to issue this order.
Well, and there's two things I'd like to say, and the first thing, candidly, is not as responsive to your question as my second thing. The first thing is that 664A.3, which contemplates evidently sua sponte modification of a no-contact order, would seem to, I suppose, arguably augment.
Well, maybe, but
augment is probably the wrong word, but
maybe, but this, in a way, this isn't sua sponte anymore. It may be desirable, but now, instead of it being on the court's motion based on review of the record, it's on a third party's motion. Isn't that a different animal?
In a way, yes, Your Honor. I think in practical effect, it is. Because ordinarily, the district court, when not asked to modify a no contact order, will probably follow the first clause of the sentence in 664A3 sub 3 that says that the no contact order shall remain in force and effect. And so, as a practical matter, yes, the sua sponte modification is not really a sua sponte modification. It is at the request of the protected party. It's worth noting that it's also, under my opposing counsel's theory, at the request of a different party in this case, the prosecuting attorney. But I think it's sort of to follow the language of State versus Hoig, that it seems to be there's a hole in the statute. And so while it says, it contemplates, I think textually, sua sponte authority, what it really is doing is it's a hole that contemplates, I think, the protected party bringing the case. And in that case, the language from State versus Hoig that inherent authority fills in the interstices of a statute when it's necessary for court administration and justice applies here, because I think it creates a efficient way to gather the evidence in the record that the language of the statute appears to contemplate.
Couldn't we find that the order exceeds the inherent authority of the court, so the order's no good, and then leave the question open whether the victim has to go to the court or through the county attorney when we have a real case? I mean, we don't have to decide that second issue if we decide the court had no inherent authority, do we?
Yes, Your Honor, although I would...
Why?
Well, because this case isn't about whether the protected party ultimately has the right to seek modification. This is not a case where a protected party was denied a hearing, where the letter came in saying, I'd like to modify my no contact order, and the district court says, yeah, too bad, I don't want to do it. Right? This is not that case, and that issue was not litigated, for example, in Henley and Hutchinson.
Shouldn't we wait for the case, if assuming this order went too far, when a victim sends a letter to the court and Mr. Ostergren or some other county attorney comes yelling, you can't do that, you have to come to my office first, then we have a real controversy and we could decide that case. I mean, I think this case, the only issue is whether or not there's inherent authority to enter this order. It doesn't turn on whether the victim can or can't go or cannot go. I mean, that seems to be the real issue in the case.
Yes, Your Honor, there's, I think, two things that I'd like to say about it. The first is that this court can do that, and I think that one of the problems with this case is, from a procedural standpoint and a posture, is that the writ of certiorari, while evidently following a hearing on one of these letters, does not directly seek certiorari from that hearing, and so it's difficult to understand what aspect of the inherent authority is harming the prosecutor.
Shouldn't the appeal have been that instead of whether this order is good or not, whether the victim could do it, and now we've changed it to whether this order is good, and it seems just a little messed up to me.
Yes, Your Honor. Although I think that it's worth discussing the inherent authority of the court, because these problems arise in myriad contexts, and there is a wealth of precedent that supports the notion that district courts have the authority to set hearings to efficiently administer justice in cases before them. And in fact, as briefed by the state, there's a duty. So if there's a legal interest on the part of the protected party of a no contact order, the district court, in fact, has a duty to afford that person a hearing under the Code of Judicial Conduct. And so while this court could conclude that the district court lacked that inherent authority, I think the case law, including State versus Abrahamson, for example, which says that the district court has the authority to set a hearing, as well as the duty that the district court has to afford persons a hearing when they have a legal interest, should militate in favor of answering the question and answering it in the affirmative, that the district court indeed has that power.
Is there any tension in your position? On page 18 of your brief, you say certiorari is also improper in this case because issuing the administrative order was not a judicial function, and yet you're relying on the court's inherent authority. If this isn't a judicial function, what is it?
Well, it's a close question. I think that there is authority that suggests that the mere fact that the issuer of an order is a judge does not make it a judicial function. And there's, in fact, a three-factor test that looks to the quality of the impact of the order on persons, of whether it is a judicial function. I think applying those three factors here, this is the issuance of the order itself, for example, did not require notice and a prior opportunity for hearing, which makes the order administrative in nature.
Okay, that may be right. But you have a number, I'm gonna put the arguments collectively. You have a number of what I'll call procedural challenges.
Yes, Your Honor.
You say that the county attorney doesn't have standing. You say it's not a judicial order. You raise the Sorcy case and saying it isn't quite, it doesn't follow appropriate certiorari procedures. How could the county attorney challenge this order? What should have happened in your view?
The Sorcy case itself actually provides a blueprint. There are two things that the county attorney could have done that I think under the terms of Sorcy clearly would have preserved error and given the county attorney standing. And I see that my time is expiring, so I hope I don't go over.
I didn't finish.
Okay, thank you, Your Honor.
You could sum up when you're done answering the question if you want.
Oh, thank you, Your Honor. The first thing is that the county attorney could have filed a motion to set aside the administrative order, could have raised, briefed, and argued constitutional and statutory points, and at that point, the error would have been preserved, and the county attorney would have had standing because the county attorney would have been party to a proceeding. Along the same lines, the county attorney could have resisted, as the county attorney did, in fact, in this case, one of these letters, raised, briefed, and argued constitutional and statutory points, which the county attorney did, and then wait for an adverse ruling, which, while the county attorney mostly prevailed in the case that's in the appendix, the county attorney would have preserved some error on that case and would have standing as a party. And so that would obviate both of those problems. And so this court should conclude from a reading of Chapter 664A from the broad and unabrogated reach of the court's inherent authority, as well as constitutional values surrounding due process, that the district court had power to issue this administrative order and should accordingly annul the plaintiff's writ of certiorari. Thank you.
Mr. Ostergren.
Thank you, Your Honor. I'd like to start talking about Sorcy. I think Sorcy supports my position because the Sorcy case includes an important caveat, which frankly was not cited in the brief, which is in Sorcy, this court noted that was not a situation where the chief judge had just simply entered an administrative order without a hearing. That's much like what we have here. I don't know how you file a motion in response to an administrative order. There's no lawsuit when there's an administrative order.
Yes, where's the case in controversy here? I mean, you have a person who went to the court, wanted a order overturned that wasn't really overturned, I don't think, and the case should be done. I mean, you've turned that into a case over an administrative order. I mean, don't you have to wait until a person goes and files with the court then picks the order up against your position, and don't you have to appeal that rather than this administrative order? I mean, don't you attack the administrative order by filing like a declaratory judgment or something? There's another way to do that.
Well, I'm going to answer your question. I don't mean it to sound flippant, but I'm going to answer it. If the court wants in its decision to say, we're going to treat this as a declaratory judgment, you won't hear an objection from me. How the procedural remedy is, I think a petition for writ of certiorari is the right way. The case in controversy language, that's from Article 3 of the U.S. Constitution. In the federal courts, that's jurisdictional. It's prudential in the state courts. You're head of the judicial branch. The trial court judges work for you. And frankly, I think as a question of law, you can say This order is vacated because we don't like it. This is a court administration issue fundamentally. It's clearly, by the way, a judicial act by Judge Rydell. If it's not a judicial act, I don't know what it possibly could be.
Mr. Ostergren, on this procedural stuff, there's a suggestion in the briefing that the original order was entered, and then you went in and asked to be heard with, I guess, Chief Judge Grieve and Judge Rydell and so forth, and then the amended order was entered. Is that right?
That is true, Your Honor.
When you went in and were heard, did you object to the process as a whole? I mean, did you raise the objections that you're raising now, or did you just seek to modify it?
We had a full and frank discussion about, I think, all the issues, Your Honor. I didn't ask to go on the record. I didn't ask for any of that. Candidly, I thought I was going to talk them out of doing it, and I obviously didn't. The difference between the first order and the second order is, under the second order, I'm entitled to notice of the victim's letter, whereas the first order could have, the letter could have gone from the clerk to the judge to the order being vacated without me knowing about it. That's the difference. Yeah, we had a discussion about it. There's no place in the rule book where you can look up how you get a formal hearing on the record for an administrative order. And the other problem—
File an application that you want a hearing on the administrative order and you object to it. That's done all the time in our courts.
Your Honor, I don't know how in our rules where you find that procedure. And the flip side of that is, I know I have a 30-day clock ticking from when that order is entered. And I don't know what rule I cite to say, time out, I've asked for a hearing. So the problem is I get stuck between those two things. And then if I wait for a real, so-called real case with an actual live breathing defendant, first of all, that case will be moot by the time we get here. Second of all, then the argument is I didn't file a challenge within 30 days of the original order, and I'm out of luck. These procedural arguments, I just think, are not well taken. The issue is in front of this court. You know what the issue is. There's really—
It seems like you're putting the cart before the horse. You're asking us to decide whether a victim can go in without going through you. And if that's the case, it probably is inherent for the court to enter an order to do that procedure. But you're attacking the order on inherent power, and we don't have to reach that second issue to reach the order issue. It seems to me, at least. And how am I wrong?
I agree that if you sustain the writ by saying the district court does not have the inherent authority to do that, then we could be back here in another lawsuit with different litigants. And I'm not saying that you should foreclose the possibility of that lawsuit. However, the impossibility of that lawsuit is why this order should be vacated, Your Honor. If I may finish answering your question.
Go ahead and answer and sum up if you want.
Thank you, Your Honor. And because this whole inherent authority argument that we've had, I think, acknowledges that there's nothing in the statute that authorizes this process. Inherent authority, as Justice Apple identified, is a situation where the court defends itself. The court says there's some circumstance which apparently has not been foreseen, which prevents us from fulfilling our constitutional duties as a court. Therefore, we're going to protect ourselves. Essentially, that's what inherent authority means. We're going to make sure the courthouse door is open. We're going to make sure some process works for litigants. Inherent authority doesn't mean we don't like the policy judgment, how prosecution works or how 664A works, so we're going to change it. That's not inherent authority. And for all those reasons, I would ask the court to sustain the writ and vacate the administrative order. Thank you very much.
Thank you. This case is now considered submitted. You may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.